Hi guys, welcome back to my channel. So today in this video I would like to continue my previous video entitled United States Maritime Attachment and Arrest. So this is the third part of the video. In fact, more recently, on October 30, 2020, in the United States District Court of the Eastern District of Louisiana, plaintiff Ping Me Maritime filed a verified complaint against defendant Jiangsu Steamship, Singapore, praying for the issuance of a writ of maritime attachment and garnishment. The complaint alleged that the plaintiff was the owner of the vessel Ping Me, which had been time chartered to Jiangsu Steamship, but that Jiangsu Steamship breached that maritime contract and caused damages. The plaintiff had already commenced arbitration in London as required by the charter party and demanded security, but Jiangsu Steamship did not agree to provide it. Therefore, to secure its claims in London arbitration, plaintiff Ping Me sought to arrest the vessel Spring Sunshine. Notably, defendant Jiangsu Steamship was not the owner of the Spring Sunshine, but plaintiff nonetheless alleged that Jiangsu Steamship was the alter ego of the vessel owner, and therefore the vessel was subject to maritime attachment as if it was Jiangsu Steamship property. The verified complaint, supported by an attorney declaration, specifically alleged that Jiangsu Steamship could not be found within the Eastern District of Louisiana, and that the Spring Sunshine was expected to arrive within the district the next day, on October 30, 2020, and depart or any time following cargo operation. Given the exigent circumstances, the District Court issued a writ of attachment on Sunday, November 1, 2020. The District Court simultaneously issued another following a substitute process server because due to the COVID-19 restriction, the U.S. Marshal was not immediately available to serve the writ of maritime attachment and garnishment. 3 days later, the proceeding was voluntarily dismissed without prejudice. Presumably, the parties negotiated security, and the plaintiff is now assured satisfaction if its claims in arbitration are ultimately successful. Attachment v. Arrest. It is important to distinguish the rule B attachment, as in Ping Me, from rule C arrest. Unlike rule B attachment, which depend on the existence of an underlying impersonal maritime claim against the defendant, rule C arrest depend on the existence of an underlying inland maritime claim against the property. Rule C arrest. Maritime arrest is also an ancient remedy. It provides a means to enforce a maritime lien or a statutory right against property in them. In other words, the property is personified as the defendant. The U.S. is not a party to any international arrest convention, and its arrest rules and procedures are unique. Although U.S. maritime law does not allow so-called sister ship arrest, it is generally believed that U.S. maritime law strongly favors the suppliers of goods and services to vessels, and therefore many vessel supply contracts incorporate U.S. maritime law. Rule C of the supplemental rules for certain admiralty and maritime claims provide in pertinent part 1. When available, an action syndrome may be brought A. to enforce any maritime lien, B. whenever a statute of the United States provides for a maritime action in realm of proceedings and alleges thereto. 2. Complaint. In an action syndrome, the complaint must A. be verified, B. Describe with reasonable particularity the property that is the subject of the action. And C. State that the property is within the district or will be within the district while the action is pending. 3. Judicial authorization and process. A. Arrest warrant. 1. The court must review the complaint and any supporting papers. If the conditions for any interim appear to exist, the court must issue an order directing to the clerk to issue a warrant for the arrest of the vessel or other property that is the subject of the action. The verified complaint must describe the property to be arrested with reasonable particularly. It is example by vessel name and IMO number. The kind of maritime property that can arrested include vessels, freight, sub-freight, and cargo. The complaint must allege that the property is within the district when the proceeding is commenced, or that the property will come into the district while the proceeding is pending. For example, plaintiffs frequently rely upon published sailing schedules and automatic identification system or AIS to track the locations of target vessel. A court initial review of an arrest application is usually conducted ex parte and frequently under exigent circumstances, such as the imminent departure of a vessel from the port after cargo operation are complete. The verified complaint must allege a prima facie maritime lien, yet when making an interim lien claims against property, a plaintiff does not waive any of its related in personam claims against third vessel of counterparties. A maritime lien can arise under many circumstances. For example, a maritime lien against a vessel may arise in connection with seamen's wages, salvage, general average maritime torts, ship's mortgage, and supplies of necessaries. Additionally, a carrier may have a maritime lien against cargo for unpaid freight, but this lien processory and therefore it must be enforced before the cargo is released. Most U.S. maritime liens arise automatically and do not need to be recorded anywhere. When a plaintiff establishes Rule C prerequisites, a court must issue an order directing the clerk to issue a warrant for the arrest. In order to minimize potential adverse impact on innocent third parties, an order for the arrest of a vessel customarily permits the vessel to continue cargo operation and to shift within the terminal or port so long as it remains within the district. The clerk of the court then issues a warrant for arrest. The warrant is usually served by U.S. Marshals, who will require the plaintiff to advance costs and may also require the plaintiff to insure and indemnify the marshals. The amount of advance deposit and conditions for the U.S. Marshals service vary from the district to district. A plaintiff should be familiar with local rules and procedures, and close coordination with local authorities is essential. Upon court order, the seized property can be turned to the substitute custodian retained directly by the plaintiff. The plaintiff cause of holding the property in custody recoverable. Nonetheless, plaintiff should consider the risk of potentially excessive custodial charges cost before commencing arrest proceeding, especially when arresting relatively low value and high maintenance property. So this is the end of the article. Don't forget to watch the part 1 and the part 2. And also don't forget to like, comment, and subscribe. Bye.